Good afternoon and welcome. Thanks for being here. I'm Dave Redlawsk. I'm chair of the Department of Political Science and International Relations and the current holder of the James R. Soles Professorship. I'm absolutely pleased we're able to have Mr. Floyd Abrams, the noted First Amendment attorney, join us today, and thrilled to have you here to listen to him. Before we turn to our main speaker, I just want to say a brief word about this event. This lecture is in celebration of both our late colleague, James R. Soles, and of Constitution Day, when we consider the role that this unique document has guided our country for nearly 230 years. Our Constitution Day recognition this year focuses on the First Amendment, which reads in its entirety, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances." I've always found it absolutely fascinating how a statement so short has had such impact on the nature of what we call democracy in the United States. I think its core message, actually, though, was articulated by Justice Robert Jackson in the 1943 flag salute decision, West Virginia Board of Education versus Barnett, a decision that seems particularly relevant at the moment given some of the discussion going on about flag salutes and standing for the national anthem. Justice wrote, "If there's any fixed star in our constitutional constellation, it is no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein." In some ways, supporting the First Amendment is easy when we agree with what's being said. But it seems especially appropriate to keep in mind something important from our speaker, Mr. Abrams. He wrote, "It just seems to be a human trait to want to protect the speech of people with whom we agree. For the First Amendment, that is not good enough. So it is really important that we protect the First Amendment rights of people no matter which side of the line they are on." Let me close by saying I am proud and humbled to be the newest holder of the James R. Soles Professorship. While I did not know Professor Soles, what I have learned makes it clear that his are mighty shoes to fill. As you'll hear in a moment, Jim Soles was an amazing treasure for our department, for the university, for the state of Delaware, and particularly for the generations of his students. I am pleased that we can recognize his important contributions through this lecture series. I'll now turn things over to Edward Freel, who will tell us a bit about James Soles and civic engagement. Thanks again for being here.
Good afternoon. Let me begin maybe with a couple of acknowledgments. We have, not that everybody here isn't a special guest, because you all are, but maybe to single out a few people. We're joined by the Honorable Leonard Stark of the Federal Court of the State of Delaware. Judge Stark, it's great to see you. A former Jim Soles student. In fact, as I recall, I think the night that the judge heard that he had been confirmed by the Senate, he was actually having dinner with Jim Soles, as I recall, if I'm right on that. We're also joined by our provost, Domenico Grasso, and we very much appreciate that you're with us this afternoon. We're also joined by Jim's daughter, Catherine Soles Pomeroy, and we're very, very happy that Catherine, and one of these years we'll get Nancy from the West Coast to come over and join us also. Well, thank you for the opportunity to say a few words about Jim Soles and how this lecture came about. It's important, I think, as we move away from Jim Soles' active time at the university and his passing 6 years ago, that we pause and remember what made him so special. I suspect that I was asked to speak today because I do have some history with Jim. I was his grad assistant in 1969. Hard to say. And I was his campaign manager in 1974 and a mentee for life. And 6 years ago, I had the honor to speak at his memorial service. Jim came to the university in 1968 and remained here as a member of the political science faculty for almost 35 years. His primary areas of academic concentration were the Constitution and American politics. He received the university's Excellence in Teaching Award twice, and was, at least in my time frame that I can remember, he was the only faculty member I know who was chosen by the senior class to deliver their commencement address. Dr. Soles was famous for his courses encouraging students to engage in the world of politics and public service. His courses in the 1970s gave many students their first political experiences, and I can look out at the audience and I see a couple from that class of 72 here. As a sidebar, he also became known nationally for his one-man stage portrayal of Founding Father James Madison. In 1974, Jim ran for Congress, and while unsuccessful, the campaign introduced Jim to the broader Delaware community. He would go on to advise many of our state's most well-known public leaders and to become our state's premier commentator-in-chief. Jim Soles also practiced what he taught and ventured well beyond the walls of the university, serving on many boards and commissions, including leading the Delaware Heritage Commission and the board of Delaware Technical and Community College. Most of all, Jim was a mentor to thousands of Delaware students, many of whom went on to careers in law, government, and public service in general. And a number of them are here today. As a number of the people in the room can attest, Jim was a great advocate who also knew how to apply a kick to a mentee in need of one. Near the end of Jim's career, former students and friends came together to create and fund the Soles Foundation to support students and student engagement. Since its creation, over 75 students have received direct stipend support and assistance. I might note, when you leave the hall today, there's actually some information provided on the tables about who the students were, where they've had the opportunity to study and work with their support that they received from the Soles Foundation. So take a look at it when you're leaving. It's quite impressive. In addition, as David mentioned, the foundation supports the James R. Soles Professor of Political Science chair, which was ably filled for a number of years by Dr. Joe Pica, who is here with us today and now being assumed by our new chair. Welcome to Delaware, David. For those charged with developing a program to celebrate the Constitution, it was natural to connect that celebration with Jim Soles and his longtime commitment to the Constitution and civic engagement. A second fund was set up and funds raised specifically to support this annual election. As we leave today, after a vigorous discussion about the First Amendment led by our distinguished guest, I hope we will also remain true to Jim Soles' love of our Constitution and the spirit of civic engagement that he championed. Now I'll turn the podium over to my colleague, Wayne Batchis, to introduce our distinguished guest. Thank you very much.
Thank you, Ed. Thank you all for coming out this afternoon. I'm Wayne Batchis, Associate Professor of Political Science, Director of Legal Studies here at UD. It's an honor to introduce the 6th Annual James R. Soles Lecture on the Constitution and Citizenship. I'd like to thank Dave Redlawsk, Ed Freel, Nancy Kohler for helping make this lecture possible. So today we celebrate the Constitution. Right? We're all familiar, of course, with those 3 opening words of the preamble of this great document, we the people. Right? We rightfully celebrate this as a bold assertion of our democratic heritage, a radical statement that it's the people, right, who are to be in control of their own destiny. However, to me, these words, we the people, have another meaning as well. Right? It's a meaning that quickly becomes clear to my students of constitutional law, and it's this. Right? We, the people, are still writing the Constitution. Right? Every day, we, the people, must wrestle with this sparsely worded document. We must determine what its grand principles mean, in an ever-shifting world. We, the people, must translate the Constitution's ideas, the Constitution's ideals, and make them something real, something that affects our everyday lives. Indeed, it's easy to forget, right, that our most basic rights are a product of this interpretive work. Many Americans don't realize, for example, that the freedom of speech, the freedom of press that we all take for granted today, sat as just empty words on parchment for more than 100 years before we, the people, finally gave those words meaning. Of course, we should be honest. Right? Some of we, the people, deserve a little more credit than others. But for the likes of Oliver Wendell Holmes, Louis Brandeis, we likely would have a very different First Amendment today. So today I could not be more privileged to welcome another in the pantheon of First Amendment greats, Floyd Abrams. His tireless advocacy for robust freedom of speech and press is quite simply unparalleled. He has argued many of the most consequential First Amendment cases before the U.S. Supreme Court. It would not be an exaggeration to say that the First Amendment would not be what it is today but for Floyd Abrams. A graduate of Yale Law School, Mr. Abrams is a senior partner at Cahill Gordon in New York City. Please help me welcome to the University of Delaware, Floyd Abrams.
Thank you, Wayne, and I want to tell you all that I might have lived here. I was a law clerk in Delaware for 2 years for a federal judge. I thought of staying. I almost stayed, and I didn't, and look what became of me. But I had 2 wonderful years here. And every time, anytime I'm ever asked to speak here, I come. I wanted to talk to you today about what might be thought of as American exceptionalism in the law, not exceptionalism in the sense that political figures sometimes use as if we have nothing to learn from foreign countries, as if we are what we are and we are an island in the world. I wanted to talk about how different we are with respect to the First Amendment than even the most democratic countries elsewhere in the world. But because this is a celebration of the Constitution, I thought maybe I'd start with just a little history first. Delaware, of course, was the first state. I learned stuff when I was here. And I'd really have to start with just to give you a picture. I mean, think of it. Philadelphia, the same Philadelphia that's not so far from here. 1787. There's a meeting purportedly, at least in the first instance, to make some revisions in the country as it then existed and the governing documents. What became was a rewriting entirely, the creation of a country, which really had not existed till then, because what had existed was 13 states, allied, friendly, but not singular. There were 13 states, plural. The United States were 13 states. And in Philadelphia in 1787, that became singular. the United States of America, a country, one country. And so they sat and wrote a constitution which set forth how the government worked. This was not an effort to write a beautiful piece of poetry. This was not the Declaration of Independence. This was not Thomas Jefferson writing his heart out and then being edited to his great unhappiness by his colleagues in Philadelphia. This was not revolutionary rhetoric. This was a blueprint, how to create a functioning government. What does the president do? What does Congress do? What does the judiciary do? How do we amend the Constitution if we want to change relationships between the branches of government? What is the relationship, to some extent at least, between the new federal government and the states? And when they met in Philadelphia, they disagreed on a lot of things. One thing they agreed upon was this: there would be no Bill of Rights. A proposal was made to add to this description of how the newly empowered government would work, to add a list of things the government couldn't do, areas into which the government couldn't go. And the reaction, and it was late, it was September, people were tired, and they had worked very hard and agreed astonishingly on the draft, a whole draft of the Constitution. And someone stood up and said, I'd like to make a motion, and the motion was to add a Bill of Rights. The vote was 10-0. 10 states, 3 states weren't there that day, 10 states voted no, including Delaware, to having a Bill of Rights. Why did they do it? The major argument was, why do we need it? We didn't say that Congress, and remember, the Constitution was setting forth the powers, the delegated powers of Congress, what they could do, what the president could do, what the judiciary could do. The argument was, we never said anyone could limit freedom of the press. Why do we have to start listing the things that cannot be done? And Alexander Hamilton, long before he was a musical comedy star, when Hamilton had enemies and not just singers around him, Hamilton wrote in Federalist 84 a long and an almost impassioned argument against having a Bill of Rights, a combination of why should we start specifying what cannot be done when there is no justification for any of these things happening in the first place. And look what trouble we'll be in if we start listing. We're going to forget things. We're going to phrase things in ways people will argue about forever. Why don't we just leave it the way it is? We have a Constitution, and basically leave the rest to history to work out. But that there was no need, no justification for having a Bill of Rights. In fact, Hamilton said, and now I am quoting, the Constitution itself is a Bill of Rights. The other side had been really led from Paris by Thomas Jefferson. Jefferson had written again and again to his very close friend, James Madison, and urged on him the proposition that a Bill of Rights is what every free country was entitled to, what every free person in a free country was entitled to, and that it was absolutely essential that a Bill of Rights be added. Madison himself was ambivalent. His view, he said, was that the Bill of Rights is like a parchment which will blow away the first time the first time the public wants to do something, they want to do it enough, they'll wind up doing it with or without a Bill of Rights. Madison said it's like a married couple on their marriage night, promising various things to each other. Things happen through the years, Madison said, and it's not a great idea. Well, the Constitution itself had enemies that it had to be ratified by 9 of the 13 states. And it was not clear that the votes were going to be there from those 9 states ratifying it. Some people in those states genuinely believed with Jefferson that it was a very good idea, and indeed an essential ingredient of the new Constitution to have a Bill of Rights. Others used it as a basis of justifying non-ratification and argued whether or not they cared about a Bill of Rights, argued that their states should not ratify because there was no Bill of Rights. And eventually, when they adjourned in September of 1787, there was no Bill of Rights, but there was still extant a lot of talk about having it. And by 1789, when the Congress started to address these issues, by that time, Madison had come to the view that at least as a strategic matter, and maybe history doesn't tell us the answer to everything, maybe because Madison had really changed his mind, that it would be a good idea to have a Bill of Rights after all. One of Madison's observations was, it's a lot better, this is my 21st century translation of it, but it's a lot better for us to be the ones to push a Bill of Rights through rather than enemies of the Constitution who don't want anything this to be ratified anyway. So some states ratified, but only with a proviso that there was a Bill of Rights to be added. Other states were still considering whether or not to ratify. And Madison introduced a Bill of Rights, the first 2 of which related to the election of members of Congress and the size of districts, et cetera. Those were rejected. And the first one became the 45 words that were read to you earlier. Congress shall make no law. Now remember, when we talk about the Bill of Rights, we talk about the Constitution, in almost all respects, we're only talking about the federal government, not the states. Not till the Civil War and after the Civil War, when there were new constitutional amendments adopted, did all the provisions of the Bill of Rights apply to the states. So when we loosely talk about the Bill of Rights, we really mean the Bill of Rights as made applicable to the states after the Civil War ended in 1865. So we have a Bill of Rights, and the first Bill of Rights is the First Amendment. And it talks about freedom of religion, it talks about freedom of speech, talks about freedom of the press. What I'd like to do in my remaining time is just to offer a few examples, as I said at the start, of how extraordinarily different we are from other democratic countries in the degree to which, as a result of the First Amendment and the law that has been created since then, how different we have become than other democratic countries. And I want to limit myself now to democratic countries. I mean, in Russia recently, it has been held to be a crime to say that Russia and Germany invaded Poland at the same time together in 1939. That is criminal in Russia. It would not be in any democratic country. That's now the law there. In Poland, legislation has just been introduced, within weeks, which is likely to become law, which will make it a crime to refer to, quote, Polish death camps, unquote. One can understand the frustration of Poland at having concentration camps established there by Germany, referred to, as they often have been, as Polish camps or Polish death camps. But that's not what I'm talking about. Those are easy cases, easy First Amendment cases. Here, almost too easy. You don't need a First Amendment. You just need to believe in freedom of speech generally to say, we can't keep people from saying this. We can't keep people from saying that. Here are the hard cases. Let me give a few examples and a few comparisons. One is hate speech, speech that is critical of, demeaning of, often personally destructive of the feelings and reactions of people who are victimized by it. Canada, just a few years ago, had the following case. A religious zealot, I think it's fair to say, was outraged that high schools in Saskatchewan were about to teach about homosexuality. He printed flyers to put in mailboxes all around Saskatchewan, denouncing the new decision to teach about homosexuality in high schools, saying things like the following: if Saskatchewan sodomites have their way, your school board will be celebrating buggery, that the teaching would be telling, quote, children how wonderful it is for two men to sodomize each other, and on and on. That speech was held to be criminal in Saskatchewan under a Canadian law that prohibits expression that ridicules, belittles, or otherwise offends the dignity of any person or class of people. Canada has their equivalent of the First Amendment. It was raised as a defense or as a basis in their Supreme Court for saying that this man could not be punished, jailed, fined for saying these things. The Canadian Supreme Court affirmed the conviction of the man, and they explained why hate speech can be banned in a democratic country. They said, hate speech is an effort to marginalize individuals based on their membership in a group, using expression that exposes the group to hatred. Hate speech seeks to delegitimize them, reducing their social standing and acceptance within society. Hate speech, therefore, the Canadian court said, rises beyond calling distress to individual group members. It can have a societal impact. It lays the groundwork for later broad attacks on vulnerable groups. It impacts a protected group's ability to respond to the substantive ideas under debate. The ultimate conclusion of the court was that, quote, the benefits of the suppression of hate speech and its harmful effects outweigh the detrimental effects of restricting expression, which by its nature does little to promote the values of freedom of expression. American law is flatly, unambiguously, totally to the contrary. When a family of religious zealots that formed what it called the Westboro Baptist Church carried signs 1,000 feet away from a church where the death of an American soldier in Afghanistan was being mourned, in an area where the police said they could stand, and their signs denounced the soldier and said his death was deserved because of American tolerance of gay people. Similarly bigoted language was held protected by the First Amendment. These are signs saying God hates fags, fags doom nations, etc. And what did our Supreme Court, by an 8-1 vote, say about that? They said, while these messages may fall short of refined social or political commentary, the issues they highlight, the political and moral conduct of the United States and its citizens, the fate of our nation, homosexuality in the military, are matters of public import. The speech is fairly characterized as a speech on a matter of public concern and thus must be protected by the First Amendment. The court even went farther. They said that that speech was entitled to what it called special protection because of the public importance, however crudely and destructively, the public importance of the issues being raised by the speech. Quote, such speech, the court said, cannot be restricted simply because it is upsetting or arouses contempt. And they answered, without aiming at Canada, the Canadian view and the view in all of Western Europe, that hate speech does little to promote the values underlying freedom of expression by basically saying that the ultimate First Amendment value is the avoidance of government censorship over speech without regard, without assessing the value of the particular speech itself. Chief Justice Roberts rejected a balancing test proposed by the government, which would have read as follows: whether a given category of speech enjoys First Amendment protection depends upon a categorical balancing of the values of the speech against its costs. That balancing test, how valuable is the speech, what is the price we pay for the speech, was rejected in almost merciless language by our Supreme Court, saying that that test was startling and dangerous. The First Amendment guarantee of free speech, the Chief Justice wrote, does not extend only to categories of speech that survive a balancing test of relative social costs and benefits. And in critical language, the court said, the First Amendment itself reflects a judgment by the American people that the benefits of its restrictions on the government outweigh the costs. Now, this is a unique position in the democratic world, and it has led to strikingly different results politically, socially, culturally in these nations. Throughout Europe, for example, harsh and accusatory criticism of the alleged misbehavior of Muslim immigrants from Islamic nations has led to criminal prosecutions for the speech, prosecutions that would be literally unthinkable here. In Belgium, a member of parliament and the leader of a right-wing political party was convicted in 2009 for distributing leaflets calling for, quote, Belgians and European first, unquote, policy, and saying, quote, stop the sham immigration policy, send non-Europeans home, and stand up against the Islamification of Belgium. He was convicted of incitement to racial discrimination, disqualified from holding public office for 10 years, and sentenced to community service. The European Court of Human Rights, the closest equivalent in Europe to our Supreme Court, affirmed the conviction, saying that such literature, quote, sought to make fun of the immigrants, leading to hatred of foreigners, particularly by less knowledgeable members of the public. Similarly, in England, an individual was tried and convicted for carrying a poster that showed our World Trade Center ablaze with the caption, "Islam out of Britain, protect the British people." The European Court let that conviction stand, saying that the poster constituted a public expression of attack on all Muslims in the United Kingdom and could thus provide a basis for criminal sanctions. In a later case, a very, very recent case, weeks ago, a speaker was convicted of violating English law after posting statements that were deemed grossly offensive to Muslims, including one say, "Don't come over to this country and treat it like your own. Britain first." This is not a political speech I am making, but I have to say this before proceeding, to say that an apt comparison is the American legal reaction, and I think our cultural one as well, but certainly a legal one, to a number of statements by Donald Trump in the course of his campaign for the presidency, ranging from denunciation of Mexicans to repeated proposals to ban all Muslims, at least for some unspecified time, from entering the United States. There was a lot of criticism, public criticism of Mr. Trump for those statements. The one thing no one has ever said is that those statements should be deemed criminal, or that criminal punishments should be available for such speech, let alone by a candidate for president. So how different is the American approach to issues like these? There's a document called the International Covenant on Civil and Political Rights, drafted in 1966 and later on ratified by just about all the democratic countries of the world. One provision of it says, any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. We have law about incitement, but it is very narrow, very restricted, and very speech protective. As a result, when the United States ratified the convention, it was with the express written reservation that, quote, Article 20 does not authorize or require legislation or other action by the United States that would restrict the right of free speech and association protected by the Constitution of the United States. That's how different we are, because another way to read that is we won't do it. We will do it by education, but we will not do it by statutes barring speech, even as offensive and outrageous and wounding as that speech, that sort of speech, is. And we do it all because of the underlying theory or basis of the Bill of Rights as a whole, and the First Amendment in particular, that it is a protection against the government and therefore unwillingness to let the government make judgments, even in good faith, even with perhaps some good results of it, for the government to make judgments across the board as to what can be said and what cannot be said. So that's why when you read through American cases, you come upon again and again language. This is one from Justice Jackson that you quoted from earlier, not the same opinion. writing in 1945, "The very purpose of the First Amendment," he said, "is to foreclose public authority from assuming a guardianship of the public mind through regulating the press, speech, and religion. In this field, every person must be his own watchman for truth, because the forefathers did not trust any government to separate the true from the false for us." Or Justice Hugo Black, writing in 1960, "The very reason for the First Amendment is to make the people of the country free to think, speak, write, and worship as they wish, not as the government commands." Let me offer a few less emotionally fraught examples of the level of difference between American First Amendment law and that in effect in other countries. Libel law, saying defamatory and false things about other people or the like. The libel law in England has for generations been very clear that any statement you make which is defamatory, critical of, holds someone up to ridicule or obloquy, as we lawyers say, that any such statement is presumed to be false, and the person who says it has to be able to prove it. We take it the other way. We say speech is presumptively protected. If somebody wants to bring a libel suit about something said about him or her, he or she has to disprove what was said to make it clear that what was said was not accurate. As a result of this and a wide range of other pro-libel plaintiff rules, and before England changed some of its rules, but not the one I've just read to you, England became a sort of libel paradise for plaintiffs' lawyers, with a success rate of over 90% in their cases. And a lot of strange results occurred. How many of you remember or have heard of, I speak to the younger people, Liberace? Yes, a few. You can check them out in the library or on television still. He brought a celebrated case in England against a gossip columnist who had suggested that he was gay. He won. He was gay. The law, let me say, at least in the United States, has changed since that time so that accusing someone of being gay is not something that we would say anymore is defamatory. Times change. Other example, John Profumo, the Minister of War in England, won libel damages for the published assertion that he had been sexually involved with a prostitute. He later had to confess to the House of Commons. He had to resign. Jeffrey Archer, some of you may have read some of his good, fun books, was awarded significant damages as a result of his publication of newspaper articles linking him with a prostitute, later found to be untrue. He was jailed for the false testimony that he gave. And Lance Armstrong, our Lance Armstrong, flush with drug-aided victories in about every bicycle race in the world, including in Paris 5 years in a row, brought a lawsuit against someone who had said that he took illicit drugs. He won enormous damages in a case in England, and he got settlements from English publications that we learned years later, and he confessed years later, all those things were true. A less dramatic example that for me is more telling. Cambridge University Press had commissioned a book about President Putin of Russia. which said that he had extensive connections with gangster elements in his country. Cambridge received the book and then refused to publish it, writing to the author and then releasing to the public a statement that said that as a matter of risk tolerance, it could not risk a libel suit by Putin. We have no reason to doubt, it wrote to the author, the veracity of what you say, but the risk of litigation, and in any event, the disruption and expense of a litigation would be more than we could afford given our charitable and academic mission. The book was not, still has not, been published in the United Kingdom. It was published here. Putin did not sue. Now, the reason that the book about Putin would have led anyone advising him not to sue is that we have a far more speech protective path that we have chosen. I want to be clear, these are not yes or no answers, and different societies can make rational judgments about weighing the significance of personal reputation on the one hand and the significance of free speech on the other, because sometimes they conflict. My point now is simply that our decision has been not to ban libel law, but to really making hard for a public official such as Mr. Putin to prevail, to say in so many words that he has to prove not just what was said about him was false, but that the editor or publisher, the book publisher, either knew it was false or had serious doubts about its truth. And that proposition is one which has not been adopted in almost any other country in the world. One of the things that has been adopted, I should add, is from the same case, a 1964 case of great note called New York Times against Sullivan, is the proposition that there can be no libel suits by the government. None. The government may feel, the officials of the government may feel and may rightly feel that there have been false statements published about the United States, about Chicago, whatever, even about Delaware. But there can be no libel suits because our law has said that the public has an absolute right to criticize the government, period. And that's been adopted in a lot of places around the world and is a very serious contribution by our country. We have gone so far now as to say we will not enforce a libel judgment obtained in foreign countries that don't have something like the First Amendment. That law signed just 3 years ago, unanimously voted for by all members of the Senate and almost all in the House, and signed into law by President Obama, makes it clear that in almost all circumstances, American courts may not give accreditation, may not enforce foreign libel judgments in any case where there would have been some sort of defense in the U.S. based on the First Amendment or the First Amendment-like defenses. Just one or two more examples. One of the most interesting developments in recent years has in this whole area of law has been the adoption throughout Europe of what is called a right to be forgotten. And this is a new body of law based on a 2014 ruling of the European Court of Justice, which is an effort to protect personal privacy, by saying, in effect, that Google and other search engines must remove links to content initially published in newspapers or elsewhere that reveals information that is determined to be, quote, inadequate, irrelevant, or no longer relevant, unquote. So if someone has been written about in a newspaper, any place in Europe now, and it some time ago, the person can make an application to Google saying, take my name out. And Google then decides in the first instance whether having the name in is still relevant to something or other, which makes it relevant. And if Google says, I'll leave it in, they can go to court and get an order. People that have studied how this has worked out have basically said that when you're talking about politicians or people of great power, that Google has almost always said anything about you that has already been published is still relevant because of who you are, what you're doing, etc. But not as to private people, the victim of a crime, sometimes even a criminal of a case many years before. A London newspaper has published a list of 100 of its stories that Google no longer carries because of complaints of someone or other mentioned in the story who made the case, what difference does my name make anymore? Anyway, a very, very recent case in Belgium, for example, involved somebody who was responsible for an automobile accident which resulted in the death of certain people years ago. And the interesting question, the interesting sort of public policy question is, would we want material like that still to be available on a Google? The legal question is here, would the First Amendment allow legislation which bars the publication of what is presumptively truthful information? I mean, we go very far to protecting truthful information. We even protect on purpose some false information for fear that it'll wind up preventing us from learning truthful information as well. But on the truthful side, someone would have no chance going to a court saying, look, this was 20 years ago. I haven't been in a car since then. I haven't done anything bad. Why do I have to see my name in Google? And the American reaction, legally it's too easy to spend time on, but the American justification for the body of law in this area is we don't kill history. Things happen. Things happen. Judicial proceedings. Half the cases that the London Telegraph said that their material was now out of Google were cases in court, things people said on the stand, all legally protected, every single one, and all presumptively at least true, but old from years before. This is another example not of how smart we are and how repressive they are, but simply of different systems of government weighing the value of speech and the value of keeping government out of the business of limiting speech on the one side against what Europe has decided is the transcendent value of personal value and recognition legally because of that. People like me who spent a lot of time at least thinking that we're defending the First Amendment, don't find these cases or even this conflict as difficult, I know, as a lot of people do. To me, the notion of saying you can't reprint something which was truthfully printed years ago because we have a new social policy determined by the government saying that the value of the speech is so low and the harm is so great that we shouldn't allow it. People with my views are very wary about any importation into this country of a right to be forgotten. And one of the most interesting things, and dangerous, I would say, is that there is now an effort in France to require Google not just to take down information in Europe, but to take it down here if it was published in Europe. And Google is fighting that. It's in the courts in Europe, and it will be a subject of great continuing contention. One final example, and it's one in an area of great, great disagreement about the law in the United States. This relates to the subject of the participation by people spending money to proselytize and offer their views during elections, or to put it in American legal terms, Citizens United. But let me just start this concluding example with an English case. An anti-abortion group called the Society for the Protection of the Unborn Child sought to further its cause early in the 1990s by distributing 1.5 million leaflets contrasting the views of candidates for parliament in one district on abortion-related issues. For doing so, the Society's executive director was charged with the crime of spending more than the statutory limit of £5, then $7, quote from the statute, with a view to promoting or procuring the election of a candidate. She had twice before been convicted of the same crime on behalf of her organization. So it was a crime for an organization with strongly held views about a much disputed issue of public policy and an issue of the greatest moral and political impact to spend more than $7 to distribute its leaflets urging people who to vote for or against based on their view of this issue. Now, in the case, she was acquitted on a technicality that the summons against her hadn't been served soon enough, but the courts loved the issue too much to let it go, and so they continued and decided the legality of the statute and said that notwithstanding that Article 10 of the European Convention on Human Rights, sort of like their First Amendment, did not lead to this statute being held in our words, unconstitutional. The European Court said that the statute sought to assure equality between candidates, and that interest sufficed to overcome the law's impact on free speech. They did say £5 was too little, and Parliament responded by raising it to £500. $700, can't buy a lot, but it's $700, and that remains the law today. And so, in England, if within a time period 4 to 6 weeks before an election, that society, because of its views on that issue, spent more than that amount in preparing and distributing its leaflets, it would have committed a crime. And as enforced there, the executive director would be guilty of a crime. A similar case, there's a group in London called Animal Defenders International that campaigns against the use of animals in commerce, science, and leisure, and seeks to influence public policy in the direction that they favor. They commenced a campaign called My Mate's a Primate, which took issue with keeping and exhibiting primates in television advertising, and they sought to broadcast a 20-second television advertisement expressing their views. That was illegal under English law, which flatly prohibited any political advertising. Don't cheer, please. But any political advertising at all. The English High Court affirmed the lower court ruling. The House of Lords in England, now their Supreme Court, observed that the ban on advertising on television was enacted to assure a playing field of debate that would be, so far as practicable, level, and they all cited the United States as the place where one could see what happens if you don't do that. Which brings me, in conclusion, to just a few words on the Citizens United case. I should say, I think I'm getting along with you, so I'm thinking of not saying it. But I should say that in the case, I represented Senator McConnell and argued before the Supreme Court that the McCain-Feingold law was unconstitutional for the various reasons that Justice Kennedy decided and the court decided. Basically, just to spend 3 minutes on the case, it involved a film made by a conservative political group denouncing then-Senator Hillary Clinton when it looked like she would be nominated 8 years ago by the Democrats to run for president. President Obama, of course, was ultimately nominated. It was what Justice Kennedy summarized as a feature-length negative advertisement that urges viewers to vote against Senator Clinton for president. The statute barred any broadcast on cable, television, or satellite of any advertisement that mentioned the name of a candidate for federal public office within 6 weeks of an election or a primary or the like. And so the broadcast, they wanted it to be on pay-per-view, could well have violated that statute, probably would have violated the statute, and the Supreme Court had to address the question of whether it was constitutional or not. It is one of the country's most criticized cases in our history. Polling data, recent polling data, shows over 80% of the public knows the name of the Citizens United case and disapproves of what they think the case concluded. My own view is that, as the English cases suggest, it's very dangerous for the government to get involved in limiting political speech, and that limiting money is limiting political speech. That at its core is what the 5-4 decision in the Citizens United case concluded. There has in fact been far less corporate money in this campaign, our presidential campaign, than many people had suggested, but a lot more individual and family money than had ever been the case before. And an earlier case had said that was protected, that it was so speech-like that it was protected by the First Amendment. All these cases are ones in which our law not only differs, but differs all in the same direction from the law as it exists in other democratic countries. And there are, as I hope I've made clear, very serious policy arguments that can be made for the other route, a route which is, what should I say, less vigilant in protecting what at least is argued to be First Amendment rights. But the Supreme Court, more often than not, by close to total agreement, a number of 8-to-1 cases recently that I've referred to without mentioning the name of, has said that that is the result, indeed the necessary, inherent result of the First Amendment. So when we think about the Constitution as we celebrate, as we should, the Constitution, as we think about the First Amendment, as we think about the level of protection that the First Amendment has afforded, even if sometimes we may think the protection goes too far, it's really worth celebrating that the framers overcame their initial reluctance to have a Bill of Rights at all, and therefore not to have a First Amendment at all. We would truly be a very different country if Alexander Hamilton had had his way, and if the 10 states, including Delaware, that voted against having a Bill of Rights had had their way. Not everything goes right for a country, and no country does right, heaven knows, all the time. But I submit to you that we should be very pleased and very celebratory that we protect the First Amendment to the degree that we do. Thank you all very much.
Thank you very much, Mr. Abrams. But in one way, you're misleading the audience who haven't studied the history of freedom of speech. There's been very, very dark periods in American history, as I'm sure you know. In the 1920s, where just about every dissident went to prison who brought a case to the Supreme Court. Also in the 1950s, one of the darkest periods in American history. So what you're talking about, I mean, if you think about it, the language of the First Amendment didn't really explain why it was so bad, but it was the culture, the fear of communism, the Red Scare, and later the fear of communism. So I think it's important to, I'm sure you know, because one of the people who went to prison for 20 years was named Abrams. And this was in 1919, as I'm sure you know. But just for the sake of perhaps the students, you should speak a little bit about how bad the First Amendment was interpreted by a different set of judges.
Yeah, look, I would say a few things about that. First, for all the focus in what I've just said, and all the focus on American history and the framers, all of which I think is justified, but it must fairly be said that the First Amendment that we have today is a 20th century creation, and indeed a second half of the 20th century creation. We not only had really bad times in the sense that the questioner observes in the 1920s, the 1950s, and lots of times. If you just go back in our history to before the First Amendment was interpreted in the rather sweeping way that I was describing, you see censorship often as a norm rather than an exception. You see the Alien and Sedition Acts being passed in 1798. The Sedition Act months after the First Amendment and the Bill of Rights was ratified or adopted in any event, which made it a crime, 1798, to say anything false about the president, the Supreme Court, the Congress, just about everything in Washington except Thomas Jefferson, because he was the vice president, and they left out the vice president in the list of people that you couldn't say terrible things about. So we have a history which is not only marred by in the time periods referred to, we also have a long period of time in which the First Amendment was almost ignored. I had occasion to do an introduction to a book of New York Times articles about censorship throughout the 20th century. It's one of these wonderful packed books of newspapers, just newspaper article. And if you look through it, you see routine censorship. I mean, you see bizarre cultural movies banned, books banned, Ulysses not allowed into the country until late in the 1930s, and booksellers going to jail and librarians being punished for books that they had in their library. So if you just look, because I happen to be interested in the first 10 years of the 20th century, you see, I mean, a riotous example, one after another, of newspaper editors going to jail, one for publishing details of a hanging because some judge thought that it was off limits, and at least one statute in one state made it a crime to describe a hanging. And in New York City, the New York City police distinguished between acting, which they thought was protected by the law, and vaudeville, which they thought was criminal. And so people were literally jailed for doing nightclub acts. So I didn't mean to shield you from our problems, or to suggest we don't have any today, even in this area. But that said, I do think it's undeniable that we have more in the way of protection than is true anywhere else. Yes?
Thank you. According to my understanding, the Citizens United case refers to corporations.
Yes.
Corporations were formed, according to my understanding, to protect individuals. Speech is meant for individuals.
I don't know. Do you read the New York Times?
Not every day.
Well, if you read it at all, that's a corporation, a for-profit corporation. Every television station, every university is a corporation. I understand that one could say, and I'm not trying to smooth the path to what I think here, but we have lots of corporations that I think no one would think should be without First Amendment rights. But in my view, even if you focus only on for-profit corporations, and even if you focus only on corporations that have no press-like function at all, it seems to me that we should be looking not at their corporate status, but whether we think that for one reason or another, there are such reasons, certain things shouldn't be allowed to be said. So we had a case in the Supreme Court some years ago. The court didn't decide, but really interesting, involving Nike. Nike had been, a for-profit corporation with no pretensions to public education except to buy Nike sneakers. But there were many articles criticizing them for making their sneakers in foreign countries, not paying their workers enough money, mistreating their workers abroad. Nike published ads, letters to the editor, and the like, saying it's not true. What we did was okay for one reason or another. California court said, well, we're going to treat everything Nike says as commercial speech because their motivation is commercial, and we don't think they deserve any First Amendment protection for anything like what I just described. The Supreme Court didn't rule in the case for various procedural reasons, but it's my view that it's very important to keep those channels of communication open, even in a case where the motivation is only commercial in nature. And while at least I don't disagree with the proposition of the law that purely commercial speech may not be protected if it's false, even though political speech is protected, even if it's false. In areas in which that's not the issue, it seems to me that the distinction between corporations, even for-profit ones, and other speakers should not withstand First Amendment analysis. And in Citizens United, Justice Kennedy cited 25 previous cases, mostly involving the press, but not all, in which the courts had said that the First Amendment did protect. And I want you to know, the next speech I give, Citizens United is out.
So I have a question for you, more relevant to university campus life these days. I think it was the University of Miami faculty voted yesterday to ban a controversial right-wing speaker. And I'm wondering if, from your vantage point, we're in a hotter moment around issues like that on campuses than before.
First of all, for undergraduates, if I may put it that way, who haven't taken a First Amendment or constitutional course or anything, state schools are treated differently under the Constitution than private schools. State schools are the government, period. They are like the state. This university, where we are, is treated as a branch of the state of Delaware. And what this college, university, decides is treated as the state making a decision. Private universities generally say, we're not bound by that, but we follow the same rules, or we try to. That said, it seems to me that banning speakers is destructive on a number of levels. Legally, to ban a speaker because of the content of the speech, absent the most extraordinary circumstances, and I mean extraordinary in a way that is just unavoidable, that banning a speaker is just unacceptable. In New York, for example, Fordham University, their Republican club asked Ann Coulter to come and speak. The university said they couldn't do it after protests were heard. And they said, well, you can have her if you have other people who disagree with her, which is something that university administrators, which I am so glad I am not, university administrators trying to deal with this and survive, thought, well, maybe if we have everybody, up on the panel together, it'll be all right. I just don't think that game is not worth playing. I think it's very important that students have broad rights to invite who they want to speak, and that universities, colleges, and the like should not be disinviting people who are invited, should not be banning people, should not allow students to shut up speakers that they don't like, even though students have every right to protest, to picket, to show their disapproval, or the like. Having given a celebratory speech about the First Amendment, I have to say that the place where I think the First Amendment is most threatened in the United States today is university campuses. Last question.
Now that so many people are expressing themselves online via social media, but these are private corporations, Twitter has banned, several people, actually the speaker that the last questioner was talking about, and Facebook as well. Under the law, and in your opinion, what do you foresee is going to be the consequences of that?
That's a really very important question. Let me say first, again, as I said earlier, Twitter's not bound by the First Amendment. So Twitter can do what it wants to do. But the question that you raise is, what should we want Twitter to do? Not what are they allowed to do? I think there are circumstances in which certain speech, which may be constitutionally protected, is so potentially dangerous or the like, that Twitter serves the country and the public by not accepting it. Certain terrorist speech, for example, involves, we have seen to our harm, great harm as a result of the speech. But think how hard it is to do that they're trying now. Facebook tries now. Facebook doesn't allow certain things, and they miss things, and it's a very difficult situation. But I don't object, and I think that we are well served by some process in effect which keeps certain dangerous speech from being so easily available. I would not say that about the government for various other reasons that I've adverted to. I mean, the government has armies, the government has jails, the government can punish speech in ways which make it especially dangerous to empower it to limit speech. But private entities, it seems to me, have to take great care. Hopefully they would be harmed with their subscribers and the like if they almost promiscuously started banning disagreeable speech. But I think there is some speech which is troubling enough from a societal perspective, that they should not be criticized for banning it. Let me say a final word about the new media. I mean, we really have seen now that the internet and everything we would describe as new media has made more speech from more people, more available, at less cost than ever before in the history of the world. That is an astonishing accomplishment. It has also led to more Nazi speech, more racist speech, more terrorist speech, more child pornography speech. It has had a lot of baleful effects on our society, most of which are very difficult, if not impossible, to deal with. I mean, some of the things, child pornography itself is illegal. That is almost easier to deal with, although no one has been able really to deal with it on a very serious and pervasive basis. But the rest, that, the neo-Nazi groups have found a home. They didn't used to know how to get in touch with each other. And America is the center place, because of our liberal, protective First Amendment, for so much of the evil speech in the world. So when the French or the British, which ban hate speech, are frustrated in this area, what we're talking about right now, it's very often at us, because piped into their countries are speech which is illegal in their countries. So we're at a time when the benefits of new media, and they are extraordinary. I mean, it's really some of the most important developments since Gutenberg lived, also carry with them not only great dangers, but have led to a great harm. It may be this is just a price we're going to have to pay for the most part, but a price it is. Thank you all very much.